Investigations, they're hard work. You have to sit down as the one in charge of administering employment law, especially in Title VII or any law, that you do an investigation that has the opportunity to hear all sides. I'm coming from the public employer aspect of it, and quite frankly, everything that I had to do in charge of human resources was able to be scrutinized by a courtroom if necessary, an EEOC investigator, whoever. I had to make certain my T's were crossed, I's were dotted, and don't think that you'll have it any easier if you're in this field. I have to tell you, in human resources, when you start applying the law, about 80% of the work really deals with selection and hiring of employees. That 20% that is all the weird things that can come across in human resources includes this area. It's unique. A lot of it is not reoccurring. You might have a complaint in this area and you may never get one the rest of your career. Some of them are weird, strange, and some of them really you want to just shake your head as to, really, you actually said and did that? It's all there. It comes out in this process called investigations. Investigations, when you open this door, in my case, since as a public employer, I had to bring in an outside third-party investigator. You could technically have an internal one. I prefer to have an outside one, and that way I would have a measure of distance between myself and the outside person to make their independent verification. And then they had to do an investigation. Sometimes a person files a complaint and they say, well, this person saw this and this person saw this. You may have, typically, it's very common to have 3 to 5 people interviewed in an investigation. It's work. I've had them go all the way up to 19 different people interviewed just trying to get the facts. Here is a simple, basic aspect of all investigations. People will come forward, and a lot of them are telling the absolute truth from their perspective. They're wearing a pair of glasses, and they might have glasses and they might put them on, and it could be rose-colored tint or a blue-colored tint or whatever. They're viewing the situation through the lenses of their own life, their own values, and their own perspective. Sometimes they're telling you 100% the truth as they saw it. The next person walks into the room and they're telling you the truth from their own perspective, yet the stories don't align up. There are 2 different aspects of it. They can both be telling the truth, not lying. They're sharing the truth from their perception. You need to pay attention to that because of the fact when you rush into the aspect of, yes, they're guilty. Yes, hang them all. Number one, hanging is kind of outlawed, and especially human resources. You don't do that. In employment law, you don't do that, except for the fact you might have this visceral reaction that they violated this truth. And then the next person comes in and they have a different perspective on the same truth, and the next one, and the next one. It is pretty common to have 5 people come in and 5 different versions of the truth. And once you start meshing them together, that's when your investigator, and hopefully you, as the worker with the employment law itself, can see that there could be different versions of it, and you finally develop the truth aspect of it, all in the process that you're out there. So it could be a 706 agency where you have state and local enforcers working with you that have a working agreement with the EEOC. You have somebody receives the claims of process discrimination. In my case, my office could receive them. The state chancellor's office, located, several hundred miles away, could receive them. The EOC could receive them. And then sometimes, because of the fact you have all the different fingers in the same pot, sometimes you extend the filing time from 180 days to 300 days, depending upon what the nature of the case can be. If the claim's not disposed of, it can be taken up by the EOC for litigation if they feel nobody really was active in the process. Or they might issue a right to sue letter, or whichever it may be. There's a lot of different aspects on the interface of filing. Within the EEOC, within 10 days, they have to serve notice of the charged employer. It's a simple form letter, and it tells you right in there, you cannot retaliate against the person that filed this. That person that filed it then is classified until the end over here, really maybe not technically legally, but from a practical aspect as a whistleblower, they're actually going and telling you that this happened. The solution always preferred by the EEOC investigators I work with, which is several of them, okay, they prefer to have some type of conciliation aspect of, they says, well, this is what they said. What are you doing about this? Well, this is what we found out in our investigation. And frankly, here was violated. This wasn't. Here's the results of our investigation. Well, what about if we did this? And sometimes it's a matter of bringing in one person or a group of people and training them. Sometimes it's a matter of telling the EEOC, I'm sorry, we've done everything possible and we found this from the investigator that this simply didn't happen in this manner over here. Somebody's interpreting it. You'll get this happening, and you'll get a supervisor who you may have thought was always good. They write a 14-page disciplinary memo. If you have a supervisor doing that, you better take a good look, because in fact something's wrong in that process. Okay, or you have this over here, or supervisors oblivious to what's going on. You might have a third party coming in delivering goods in your shipping room, and that person makes sexual harassment comments to different people, admiring whatever it may be, and all of a sudden now you're stuck with, okay, this driver over here is coming in, and you got to call up the third party. And by the way, if they show up in your business, you're responsible for what happens on your site. If you don't do anything about that third party doing that, then you're going to be held accountable by somebody, maybe the EEOC. So be careful on that. A lot of times you might have the aspect of mediation. I always kind of roll my eyes on the word mediation, because mediation is not mandatory. In essence, you have a mediator available. They come in and they divide the two different groups, and they put you in one room and they put the other team in the other room, and the mediator runs back and forth. I've done most of my mediation in negotiations and contracts, but for the most part, the mediator says, you're guilty over here. You too will be punished. They go into the next room and they tell the other team, you're guilty over here. You'll be punished. So they're yelling at both people on the same issues on different sides. So it's kind of an interesting aspect of it. I've found it to be relatively effective. With that, you're getting to hear a third party coming in and saying, your side has a weakness over here. They're telling the weaknesses on the other side. You may know what the other side is, and pretty much by the time you're all done, you can go back. The mediator may come out with a settlement in the process. Hopefully, they can't impose anything, but a lot of times I've found mediation to be a very positive methodology for resolving conflict. Referral back program, sometimes claims are sent back to the employer for mediation. It just depends what it is. Participation is voluntary mediation. You don't have to have it. If you have an EEOC investigation come out, okay, they're looking for reasonable cause. Reasonable refers back to what a reasonable person, an average person walking down the street, if they saw this happening, would they view this as harassment? Would they view this as sexual harassment? Would they view this as whatever it may be? The reasonableness clause would be the average person, maybe the one that's sitting in the jury to review this as a trial. In essence, the EEOC investigator, they want to conciliate, they want to settle the claim. If they can't do that, they can file suit if they choose to do that, or they can issue a right to sue letter. The investigation that they do could be reasonable cause, no reasonable cause. It just depends what the outcome of what they want. So with that, the right to sue letter doesn't mean the person can sue. Usually the right to sue letter is a positive thing, because that investigator couldn't find anything that on behalf of the employer as to what was wrong in the situation. So therefore, hey, sue them if you want to, good luck. And they walk away from it. And you have them saying they couldn't find any reason. The employee after that, they can file in federal court within 90 days. Sometimes when you go to court, the judge wants you to go and settle, but really, once you have the right to sue letter, in essence, there's not much basis to what was said in the process. So that helps you, but it doesn't clear you in the process. Judicial review. Sometimes they'll review an EEOC's decision in federal court. Sometimes a jury trial can be requested by either party. If that happens, your attorney that you're working with will go through and help you with this aspect as to what can be said, what can be revealed, and get different court documents in the process as well. You'll see that, and it's quite a lengthy aspect as to what's involved with preparation for court. De novo review. It's a new look at the claim by a reviewing court. They may take this okay, the trial, and then by the time it's all done, whichever determination was, they'll look at the agency as well, and the court may just take a look at it and see what's out there, and it could be available up to even the Supreme Court to review what the process was, saying we can't find any basis here or fault with the decision. Mandatory arbitration can also be their private judging. The employers and employee, you can have a list of arbitrators, typically the American Arbitration Association, AAA. They're out there, and typically, at least in California, most of them tend to be attorneys. People with vast experience on employment law are also part of it, but they're available to come in and arbitrate a case. It's mandatory, and almost always the decision is much more binding and permanent and cannot be appealed to court. Although technically sometimes they can, but it's less equictive. And the biggest thing is it's quicker and you get it done better. And in some ways, it may be even more impartial in the process. But keep in mind, the goal of an arbitrator is to make a good decision. It's also to get more people to use their services in the arbitration process as well. So I'll let you interpret whatever that could possibly mean. But the reality, they're looking for more fees long term, so they want to make certain both sides have some benefit out of it to want to use them in the future. But that being said, it's less expensive, quicker, final. You can get certified to do arbitration or mediation, especially relatively easily. For mediation, arbitration's harder because you have to have a whole history of solid mediation or other kinds of arbitration as well. Claimants are forced to arbitrate if the proper agreement terms don't poison the process by tilting the playing field one way or another. A lot of times the EEOC, there's a hostility there that's a barrier to the entire agency's mission in the process. So you want to have that aspect. The EEOC is an administrative agency, and they are to follow the parameters as set forth by Congress within their charge. And if they're exceeding that, you may have a problem, and you have to go to court to deal with that as well. Title VII training, I had included train here for training. Anyhow, discrimination claims, they have to be proved just as any other lawsuit. The employee has the burden of proof. In theory, the employer is innocent until proven guilty. In theory. Sometimes they can sit down and just make your life absolutely miserable, and you might have to spend thousands upon thousands of dollars over one claim that's specious in the aspect of there's no merit or anything else. So it just depends what you have out there. Sometimes settling might be easier to sit down and deal with the complaint than going through the difficulty, but that's a judgment made by every employer and every employee. What Title VII, the training, make certain if you have training, make certain the people, especially your supervisors, know what it is, what it requires, and who it applies to, how the actions can bring liability, what kinds of actions in a proceeding. If you have somebody going into court or any type of a hearing, make certain you brief them ahead of time. Employees have a right to a workplace free of discrimination or harassment. That's how it should work. So make certain you're paying attention to exhausting the administrative remedies, which is what Title VII really is about, and the EEOC as well. Too often, there's 5 or more people out there. Choose, if you can, mediation. Listen to mediation. My experience is it's worked in almost every case I've used it. Pass Around Act. They'll sit down there. If you beat EEOC, you might get passed around to a different agency and a different agency. I've seen that happen in my experience. Mandatory arbitration. Whenever it's mandatory, it's binding arbitration. The employee has the burden of proof, but occasionally you'll see an investigator may decide to assume that burden of proof and blame the employer. Be careful on that. Don't make accusations. Just watch what's going on. Have a record of annual training for all supervisors with the people that attended. Make certain you have them signing in. So no matter what, have that aspect of it. Investigations are the heart of actually a complaint, and doing a good one thoroughly that's on record, having solid training on record helps an awful lot in all these cases, and listening to people and knowing that the investigator is a human being with a job to do as well. Paying attention and listening to both sides can often calm a lot of waters for an investigation. Take care.